Sally. I wanted to change the tone slightly of the speeches so far and talk, I hope, hopefully in simple terms, about why the presumption of innocence is important and what we can do to protect it. So my discussion of this is necessarily going to be general. At the heart of the problem we have at the moment are two common law principles. One is that we're discussing today, and that is the presumption of innocence. The second and more difficult principle, although there's no doubt about it, is the sovereignty or supremacy of Parliament. And that supremacy of Parliament enables Parliament to enact laws that override common law principles, including the presumption of innocence. But why is the presumption of innocence important? I know as a matter of intuition, it seems to be something that is important. But I just wanted to canvass what I think is the history of the presumption and just explain why that's so. The presumption of innocence can be traced back, at least in England, to the Magna Carta of 1215. And although not expressly referred to in it, the Magna Carta does provide that no person shall be seized or imprisoned except by the lawful judgment of his or her peers. A short but really important statement. The rule represents one of the main bases upon which we can lawfully be deprived of our liberty. It provides for our liberty unless we are convicted of a crime. However, the Magna Carta does not say in what circumstances a person should be convicted and deprived of their liberty. This key rule of law principle would have little meaning if convictions could be obtained with little more than an accusation. If the principle is to have any meaning, then there needed to be another principle that set the bar as to when a person could be deprived of their liberty. That principle is in part the presumption of innocence. And the presumption of innocence falls into two parts. First, that a person should not be found guilty of a crime unless there is a reasonable doubt that they committed the crime. Full stop. That is a rather self-evident statement. But if there is a reasonable doubt of a person's guilt, then on no acceptable basis should they be deprived of their liberty. The second main part to the presumption of innocence is the burden of proving that there is no reasonable doubt lies on the prosecution, not the defendant. In the United States in the late 19th century, it was thought that the burden of proof was not part of the presumption of innocence, but that didn't last very long, fortunately. Under the United States Constitution, Articles 5 and 14, which are based on the Magna Carta, provide in part a guarantee that no person should be deprived of their liberty without due process of law. The United States Supreme Court has interpreted these articles as including a presumption that the prosecution should bear the burden of proving the guilt of the accused. That same thought, that same principle, has been referred to by Chief Justice French in the High Court in a case to which I would return. He held that the presumption of innocence in criminal proceedings is an important incident of the liberty of the accused. Based on those statements, it's easy to see that the presumption of innocence is part of the very fabric of the Magna Carta, both as to establishing reasonable doubt and to whom the burden of showing no such doubt exists, at least in criminal proceedings. But despite the fundamental importance of the presumption of innocence, it is only a common law rule. It is subject to what I've previously said to be the supremacy of Parliament. Laws passed by an Australian Parliament, subject only to rules of construction, common law rules I might add, override the presumption of innocence. This is the cause of the problem we now face. There has been a courageous suggestion by Justice Kirby that the presumption of innocence is part of the assumption about a fair trial to be found in the Australian Constitution. His Honour was in dissent, and that proposition has gained no traction with other members of the High Court. But clearly what His Honour had in mind was to find a way by which the presumption of innocence was given greater stature than a mere common law rule to be overridden by parliamentary supremacy. Attempts to bypass the presumption of innocence are not new. Perhaps Australia's leading jurist, Sir Owen Dixon, who retired as Chief Judge of the High Court in 1964, was alert to the very problem of the Commonwealth Parliament overriding the presumption of innocence. In the Communist Party, many of you will know, that he indicated the importance of the rule of law principles by stating the rule of law was the assumption on which the Australian Constitution was based. In making this comment, he was very much alert to the impact federal legislation was trying to have and would continue to have on the rule of law principles. Writing extrajudicially in 1957, he made reference to courts treating federal laws as the paramount consideration, mindful of the part played by common law principles. Asked what it was that he had in mind in making these comments, he referred to the many attempts made by the draftsmen of statutes over a long period of years to reverse the presumption of innocence. So Owen was of the view that draftsmen had not managed this very well in the face of court judgments. The situation we find ourselves in 2021 is very different to the comments to 1957 when His Honour made those comments. The draftsmen of federal and state legislation now easily managing to reverse the onus of proof. The supremacy of Parliament, courts cannot, Owen Dixon foresaw the very problem we now face. The Institute for Public Affairs has been tracking Commonwealth inroads into a number of common law principles, including the presumption of innocence, going back to the 1980s. There are a considerable number and the list is growing. New legislation, of which we are inundated by Commonwealth and state governments each year, often result in new criminal offences, and reversal of the onus of proof to assist prosecutions often goes hand in hand with that. So what can we do about this creeping war on the presumption of innocence by parliaments? The answer many would propose is a Bill of Rights, with some good justification as well. Australia is one of the few Western democracies that does not have a Bill of Rights. I have discussed elsewhere that the rule of law principles were the result of bitter disputes in the form of wars, civil and international. In case of the Magna Carta in 1912, King John had lost London and other parts of England in the civil war with the barons. The 2097 amendment to the Magna Carta, which is held in the Australian Parliament, which restates this common law principle of liberty, was to enable King Edward III to raise taxes to fight William Wallace in Scotland. The American Revolutionary War preceded its constitution, and I've already referred to the guarantee that no person should be deprived of their liberty without due process of law. World War II resulted in the Universal Declaration of Human Rights and the European Convention for the Protection of Human Rights and Fundamental Freedoms. The European Convention contains the presumption of innocence in Article 6.2. It is given force of law in the United Kingdom by the Human Rights Act 1998 that provides, as far as possible, legislation must be given effect in a way that is compatible with the Convention. This has had a significant impact on the law relating to the burden of proof by the reading down of provisions that reverse the onus of proof from legal to evidentiary. We'll stop. Despite Brexit, the Act remains in force. The Canadian Charter of Rights and Freedoms, which form part of the Canadian Constitution, begins with the statement expressly stating that it recognises the rule of law. The South African Bill of Rights, which forms Chapter 2 of its Constitution, contains a presumption of innocence. Even in circumstances where a state of emergency is authorised, in South Africa, the presumption of innocence is non-derogable. Australia has no Bill of Rights to protect individual freedoms. Victoria, it is true, has a Charter of Human Rights and Responsibilities Act, which was passed in 2006. Section 32 of that Act provides, insofar as possible to do so consistently with their purpose, all statutory provisions in Victoria must be interpreted in a way that is compatible with human rights. One of those human rights is that a person charged with a criminal offence has the right to be presumed innocent until proven guilty according to law. This section was put to the test by the High Court in Monsalivic versus the Queen in 2011. The defendant was an IP lawyer that had been found guilty of drug trafficking. Drugs were found in her home, and under the Drugs Act, they were presumed to be in her possession unless she could satisfy the court to the contrary. Her partner, who was living with her at the time, was tried and convicted of drug trafficking. He gave evidence in her trial. He placed the drugs in her home without her knowledge. The High Court, by a majority, held that Section 32 of the Charter was a valid rule of statutory construction. Accordingly, Victorian statutes must, in appropriate circumstances, be interpreted in a manner that is compatible with various human rights, including the presumption of innocence, in encouraging development. The circumstances of this case, though, it was unnecessary for the High Court to apply Section 32. It found that as a matter of construction, the presumption in the Drugs Act by which Vera Monselevic was presumed to have drugs in her possession did not apply to the offence with which she had been charged. Her conviction was overturned and a retrial ordered. Whether or not Australia should have a charter or a Bill of Rights is a difficult question. Parliaments at both the federal and state levels continue to make inroads into the presumption of innocence. A Bill of Rights has been upheld in Victoria as a proper basis on which to construe Victorian statutes. However, the prospect of a Bill of Rights in the short to medium term in Australia seems highly unlikely. No significant group of people, at least publicly, is at present pressing for such a document. That means governments in Australia will continue to make inroads into the presumption of innocence. Once these inroads into the presumption of innocence have been made, they become difficult to remove. The circumstances in which the rule of law principles were created in terms of war and strife don't exist. But the rule of law and other common law reforms depend in large part on the public's attitude to these principles and freedoms. This is usefully referred to in the Rule of Law publication by Professor Geoffrey Walker as our attitude to these freedoms. The true source of the values of the rule of law, even in those countries having written constitutions, is to be found in the patterns of behaviour and belief of the people. To illustrate this point in reverse, despite Articles 4 and 14 of the United States Constitution, which I've referred to earlier, no one would doubt that the presumption of innocence had no role to play in the albeit fictional trial of Tom Robinson in To Kill a Mockingbird. He was convicted despite those articles of the Constitution because that's what the jury wanted to achieve. Last week, in a debate about universities adopting a free speech code, received public attention in an article by Professor George Williams. The Deputy Vice Chancellor of the University of New South Wales was arguing that protection for freedom of speech should extend well beyond universities across our society to provide every person with the right of free expression. The Federal Education Minister has threatened to legislate the voluntary code if all universities had not signed up by the end of this year. It had been suggested that the call to extend university free speech code to the nation would likely ignite the debate over whether Australia should have a Bill of Rights. Personally, I doubt that. What, however, was interesting was that Tim Wilson, the federal member of Goldstein in Victoria and a former Human Rights Commissioner, stated publicly that George Williams is right to say that Australia has a broader free speech problem in both law and culture, but the solution isn't to hand these decisions over to courts to define the limits of our freedom. Freedom must live in the culture of the public to be sceptical of centralised power. How true. So as to how we go about doing that, well, I can say that the Rule of Law Education Centre has, since its inception in 2009, worked tirelessly to educate Australians in the rule of law, including the presumption of innocence. Initially, the work we did was to try and stop amendments being made to legislation and new legislation coming into force that contained provisions that were contrary to rule of law principles. It took a couple of years, but we worked out that that was a complete waste of time. Since then, the Rule of Law Education Centre has focused entirely on education. Prior to COVID, that involved taking Year and 12 students from schools across the state and escorting them through one or more courts and explaining rule of law principles. I would like to take this opportunity at the end of this speech to thank the Centre's employees, volunteers and sponsors who make this happen. The Centre has an enormous amount of resources that are available to students and anyone else who's interested. Thank you.